Good afternoon, everyone, and welcome to another edition of Employment Law Q&A. My name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru Tumarkin, LLP. This is your opportunity. If you're tuning in right now, you're speaking to an employment lawyer and disability insurance a lawyer. This is your opportunity to get your questions answered. If you're dealing with a situation at work, if you're maybe suffering some bullying or harassment on the part of your employer, maybe your employer is changing the terms of your employment, you're being demoted or you're being offered a very different position or different compensation structure, maybe your employer is changing your bonus structure at work, or certainly if you've been let go from your job and you've been offered some sort of severance, or perhaps you haven't been offered any kind of severance at all, or if you're dealing with a medical issue at work, really, regardless of the circumstances, if you're having a hard time at work, if you're having some sort of disagreement or dispute with your employer, if something significant has happened at work, this is now your opportunity to speak with an employment lawyer and to get those questions answered. It's extremely important in these circumstances. You need advice when it comes to your employment rights. Employment laws in Ontario and in Canada more generally are actually quite supportive of employees. They're quite protective of employees. But of course, you don't know how you can protect yourself if you don't know the way the law works. And that's where we come in. We are here to answer those questions. We are here to provide you with that information and that guidance that you ultimately need in order to resolve your workplace problem. So again, this is a live Q&A. It's an employment law and disability insurance law Q&A. If you're tuning in right now and you have a question about work, maybe it's to do with pensions, maybe it's to do with whatever issue you're having with your employer, go ahead and post your question on whatever platform you're using right now. And I promise over the course of the next half an hour, I will get to your question and provide you the information and, again, the assistance that you need. A couple of items on the agenda to get the Q&A started. First off, I want to provide our contact information. You see our website address on the screen right now. That is a great starting point. If you want to know more about your employment rights, if you want to know more about contacting us and having a conversation, perhaps confidentially about your employment situation, go ahead and visit our website. Employmentlawyer.ca is where you can reach us. We've got a ton of information on our website, of course, about employment and disability insurance law. You can also email us. Our email address is on the screen right now, help@employmentlawyer.ca. Excuse me. Go ahead and email us at that email address, employmentlawyer.ca. Send us a brief email. Give us a brief description about your question or your concern, and I promise someone will get back to you. We'll be able to get back to you. Excuse me, I'm having issues with my voice apparently this afternoon. So that is really the two main ways in which you want to get a hold of us. Either email us at help@employmentlawyer.ca or visit our website, employmentlawyer.ca. Either way, again, if you're dealing with an issue at work, you need advice, you need help, go ahead and contact us there. Let's have a conversation in private and figure out what your options are, but also what your best option is and what strategies and tactics you can be adopting to, again, resolve your workplace problem. That's item number one off the agenda. Again, I want to give you guys the contact information that you need. If you want to get a hold of us off air, go ahead and visit our website or email us. Of course, do not be shy. There are no bad questions. There's certainly no charges for emailing us, no fees whatsoever. In a lot of these kinds of situations, we actually offer free consultations. So if cost is an issue for you, again, don't be shy to reach out to us. We have an entire team of intake people standing by to field questions, field concerns, and potentially then put you in touch with one of our lawyers for a more detailed conversation. So don't be shy. There's no charge for that initial contact. Second item on the agenda, before we get to the questions, and again, just for a reminder to those of you just tuning in, this is a Q&A. It's an employment law and disability insurance law Q&A. The great part of these segments and why I do them on a regular basis is it's actually quite entertaining and quite fun for me to engage with people and answer their questions and help them out. So if you're tuning in, maybe you're dealing with an employment issue, right? Or maybe you have a family member or a friend that's dealing with an employment issue. Don't be shy. Go ahead and post your question. Right? Keep it confidential. You don't have to mention the particular employer's name. You don't have to give any private information. Keep it general, keep it vague, but ask your question, whether it's severance related or anything else related. Post that question right now. Let's line up a good number of questions. And again, I promise I will get to every single one before the end of the segment. So go ahead and start entering those questions right now. They'll come up on my feed here. And as I said, I'll get to them. Now, as those questions are being lined up, I did want to talk about a matter that has come across my desk very recently. It's to do with terminations of employment. I like to give these examples because when I start seeing kind of trends across the multiple people that we speak to on any given day, we oftentimes hear the same kind of question or the same kind of point being made. And this is an opportunity to address what clearly many people are wondering about or concerned about. And so it's an opportunity to talk about a matter that I think is going to be relevant to a lot of people. And particularly in this situation, I'm talking about termination of employment. And particularly in the non-unionized work environment. So if you're a union employee tuning in, this isn't necessarily relevant to the analysis per se. But if you're a non-unionized employee, which is the majority of employees out there, this may very well be relevant. Now, oftentimes, and pretty much every single day, we have people contacting us who have been let go from their jobs. So they've been sat down for a meeting, whether that's virtually nowadays or in person. They're sat down for a meeting and they're told, your services are no longer required. We're ending your employment. Oftentimes, your employment in that situation will end effective immediately. So you'll be sat down from that meeting, and that is your last day of employment, right? You're asked to collect your belongings, right? And that's it. That's your last day. Sometimes an employee will be given notice of termination. So they'll be sat down for that same meeting, but they'll be told, your employment is terminating 4 weeks from now, or 2 weeks from now, or 3 months from now. That's not necessarily illegal in and of itself. An employer can very well provide working notice of termination. Now, as part of these conversations, of course, severance becomes relevant. If an employee is let go in any one of those ways, that employee is going to be owed severance. Severance is based on a couple of crucial factors. They're based on severance is based on an employee's age, their years of service with the company, and their position within that company. There's no mathematical formula, to be clear, that will provide for an employee's severance entitlements. I can't tell you that it's a month per year of service or 3 weeks per year of service or 6 weeks per year of service. That's not how severance works. Really, the way severance works is that the older you are, the longer you've been with the same company, and the more specialized or senior your position is, the more severance you're going to be entitled to. Ultimately, the goal of severance is that it is meant to hold an employee over until they can find comparable employment. That's why we look at factors such as age, length of employment, position, etc. Now, the point I want to make here is almost always, as part of these conversations around severance, an employee will emphasize the fact that they were very strong performers for the company, or that they had a stellar performance record, or a clean disciplinary record. And while that is relevant from a practical point of view, in the sense that when you're negotiating a severance package with an employer, of course you want that employer to have a good impression of the employee. You want that employer to think highly of the employee, to respect the employee, to be wanting to do right by that employee. And of course, the relationship that you have as an employee, even once you've been let go, the relationship you have with your employer matters in that very practical sense. I can add, however, from a legal point of view, performance or conduct when it comes to a severance negotiation is largely irrelevant. You can be the best performer in the company. You can be an average performer for the company. Your severance entitlements in those circumstances, and again, based on your age, position, and years of service, are going to be the same. Performance doesn't factor into the equation when it comes to a severance analysis. And in fact, you can be a subpar performer or there can be some issues with your conduct. You can have a bit of a record with HR of being written up or having been reprimanded in the past. That's not going to affect your severance entitlements when it comes to the termination of your employment. Again, the factors are age, position, years of service. Your performance doesn't come into that equation, doesn't come into that analysis. We field this question almost every single day. An employer or an employee rather will say, but hold on a sec, I was the top performer for the company. Why did they let me go? Or why haven't they offered me the right amount of severance? And we have to respond and say, well, actually, your performance has nothing to do with that. You can be the best performer in the company. You can still be let go in a non-unionized work environment. Your employer doesn't really need a reason to let an employee go, as long as the correct amount of severance is paid, of course. And again, secondly, it doesn't affect your severance entitlements. So something to keep in mind for employees out there. That's not to say that you shouldn't be performing well for your employer, that you shouldn't be making an effort, or that certainly your conduct doesn't matter. Well, of course, in the context of your employment, your conduct matters, your disciplinary record matters, your performance matters, right? But when it comes to a severance negotiation, as much as to the individual, those matters might feel important. Again, practically speaking, as far as the effort that they made for the employer, what they gave to their employer during their employment there. I can tell you from a severance perspective, it does not matter. Your severance is not going to change based on how well or not you performed with your employer. And again, even poor performers, even employees with misconduct or conduct issues are going to be owed severance regardless. There are examples of what we call terminations for cause. Those are circumstances where an employee's behavior is so egregious, so terrible, the misconduct is, so negligent that the employee is actually not going to be owed any severance if they're let go. Those situations are very rare. We're talking about the worst behavior in the employment context, right? Theft, fraud, physical violence, etc. Right? Again, those situations are very rare. And in those situations, an employee may not be owed severance. But if there are conduct concerns, again, it's not going to affect severance, whether it's performance or conduct, in both directions, whether you're a top performer or a subpar performer. Okay, well, with that out of the way, let's get to the questions, everyone. We're about partway through, or almost halfway through the segment. Again, for those of you just tuning in, this is an employment and disability insurance law live Q&A. If you're tuning in right now and you have a question about your work, if you have a question about your rights at work, go ahead and post your question right now, and we will get to it. By all means, there are no bad questions. There are no silly questions when it comes to employment law. Once again, my name is Alex Lucifero. I'm an employment lawyer, of course, partner with Samfiru Tumarkin, LLP. We are the employment lawyers in Canada, and specifically in British Columbia, Alberta, in Ontario. If you are in any one of those provinces and you're dealing with a situation at work, you need some answers, you need some advice, go ahead and contact us. Give us a call, send us an email, visit our website, however you want to get a hold of us. It's crucial, if you're dealing with a situation at work, that you get advice immediately. These situations cannot fester. Time is not on your side when it comes to an employment law issue. The longer that you remain silent in response to an issue at work, actually, the more difficult it becomes to resolve your situation. Right? If there's been a major change to your terms of employment, you've been demoted, or your pay has changed, you cannot stay silent for months and then take action. You need to take action right away. If, as another example, you've been temporarily laid off from your employment, right? Almost always temporary layoffs are illegal. You can actually treat the temporary layoff as a termination and obtain severance, but you can't wait indefinitely on a temporary layoff and then claim severance. You want to act right away. You just saw on the screen our email address. Go ahead and email us, help@employmentlawyer.ca. Again, if you're dealing with a situation at work, you want to contact us right away. You want to deal with the situation right away. Don't be shy to reach out to us. All right, let's line up some questions here and get into the good stuff. On Facebook, Melissa is first in line for today. She asks, I was laid off without notice and given 2 weeks pay. I wasn't provided with an ROE, and the manner in which I was dismissed was really abrasive / unfair. What can I do here? Well, Melissa, first things first, 2 weeks of pay. And I would say, really, regardless of your circumstances, Melissa, of course, and as I was just mentioning, the way in which your severance is going to be analyzed is based on your age, position, and years of service. I have to say, Melissa, I feel pretty confident in saying that, really, regardless of those factors, 2 weeks is likely well below your true severance entitlements. I'll give you a very easy example of this. Even as, for example, a short-term employee, let's say you've been with the company for 10 months, just as an example, right? In a sales position, and you're in your, I don't know, let's say late 30s or early 40s. And by the way, Melissa, if you want to give us, give me a rough sense of your length of employment, age, and position, right? Even for an employee of relatively short service in a generic position like sales, for example, and who's, let's say on the younger side of their career, even an employee in those circumstances is going to be owed something like 3 or 4 months of severance. Not 2 weeks, Melissa, 3 or 4 months of severance. So I can tell you pretty confidently, Melissa, that your severance entitlements are likely lacking. 2 weeks is not enough for an employee in your circumstances. Right? An employer, of course, needs to provide, Melissa mentioned the ROE. That's what we call a record of employment. Employers need to issue a record of employment once an employee's employment comes to an end. A record of employment will allow the employee to apply for employment insurance, for example, and it's something that an employer has to do. So, Melissa, that's another item where your employer should be issuing a record of employment. If they haven't already, that's something else that we would have to deal with. Melissa also mentions that the manner of her termination was really abrasive or unfair. I'd actually like to know more info about that. Melissa, there actually have been cases out there where an employee has received additional amounts because of the manner of their termination. I actually recall one case, and this is an actual reported decision out of Ontario, where the employee was terminated while on vacation. And the judge in that case actually awarded this employee additional, what are called damages, so additional compensation, because of how egregious and really just unprofessional the termination was in that particular case. So, Melissa, I'd like to know more details. Listen, termination meetings, of course, are never easy. They're never pleasant. Right? But if your employer was particularly nasty and particularly aggressive, right, and unfair, and again, the devil's always in the detail, right? I'd like to know more about that. That's something that you can actually potentially use as leverage to actually get additional compensation out of the employer. So Melissa ends her question by asking a question: what can I do here? The answer to that question, Melissa, is very specific and easy to answer. What you should be doing here is contacting us. Send us an email at help@employmentlawyer.ca, or give us a call at the office. Visit our website and find our contact information there. However you want to get a hold of us. Melissa, before you say anything to your employer about severance, before you respond to them, certainly I hope you haven't accepted or signed anything off accepting the severance offer. And I'll make a point in that respect in a sec. Give us a call. Let's chat about your matter. Let's figure out what your actual severance entitlements are based on your age, position, and years of service. Quite confident there'll be much more than 2 weeks of pay. And oftentimes what we'll do is nothing overly complicated or aggressive. Oftentimes we'll simply contact the employer on behalf of the employee and say, here's the way the law works. Here's the proper severance analysis. This is what the employee's owed in the circumstances. We're looking to resolve this amicably, right? Let's resolve this. And I would say almost always we're able to resolve these situations quite easily and straightforwardly. So Melissa, give us a call, contact us at the office. Let's have a chat about your matter. I'd be happy to chat with you off air and have a conversation about this. Let's make sure that we correct all of these wrongs when it comes to severance, your record of employment, and certainly the way in which you were treated upon termination. All right, next in line is RCDLP, who asks, I was laid off a few months ago, rejected the company's severance pay package, and planning to retain a lawyer to negotiate. Can severance still be negotiated if I signed a new job offer? Interesting question, RC. It really depends. So the short answer to your question is yes. Even though you've started a new job, you can absolutely still negotiate a severance package. Um, it does become a question of how much severance you're owed and potentially what the period of unemployment was. If you started new employment, that may, and I say may because it's not always the case, it may affect your severance entitlements. It really depends on what your severance is. As a very easy way to get a rough assessment of what your severance entitlements are, you can actually visit pocketemploymentlawyer.ca. The website address is up on the screen right now. Pocket Employment Lawyer, all one word, all lowercase, .ca. Go ahead and visit that website. Input your age, input your years of service, input your approximate position with the company, and out will come an assessment of what your severance entitlements may be. That'll give you a very good idea of at least the range of severance that you might be owed. Right? And so, RC, it is absolutely the case that you can still negotiate your severance entitlements. But again, right, it really depends on what your severance entitlements are, when you found that new job, what the period of unemployment is, your age, position, years of service, etc. Right? You absolutely should be having a conversation with a lawyer about this and getting into the details. Do not be shy to reach out to us. Visit our website, give us a call, right? And more than happy to have that conversation with you and get you sorted with respect to what your best option is when it comes to negotiating for your severance. All right. Next in line is Peter. Peter asks, this is on YouTube. Peter asks, can you be reduced to a 3-day work week? This happened recently. I'm not sure about my options. My boss says this is due to a lack of work. Excellent question, Peter. Thank you for asking it. The answer is this. An employer is not allowed to make any kind of significant change to the terms of your employment. Reducing your work days is obviously and potentially a significant change. It really depends what you were previously and historically working, Peter. If you've been working 5 days a week, week in and week out, for the entirety of your employment, for example, and all of a sudden, out of nowhere, and maybe it is due to a lack of work, your boss is now telling you can only work 3 days a week. Well, guess what? That is a significant. That's what that's a 40% reduction, right, in your pay. That is a major, major change to your work week and to your pay, obviously, right? That is what we call a constructive dismissal. A constructive dismissal is basically a breach of contract situation. And when I say contract, I don't necessarily even mean a written contract. Most employees actually don't really have an employment contract, or maybe they have a very kind of basic offer letter, right, that sets out the very basic terms of employment. When I talk about contract, I mean there is an implied contract of employment between an employee and an employer. It's basically what the status quo has been with respect to their employment. And so again, Peter, if you've been working 5 days a week, right, week in and week out, even though there's no written contract that guarantees 5 days a week, those are the implied terms of employment. That's the status quo. And if your employer is now changing that status quo in a really significant way, going from 5 days to 3 days, it's a breach of contract. It's a constructive dismissal. What does that do, Peter? That gives you the right to say, no, I'm not accepting this change. I don't agree to the 3 days a week. And you put the employer between a bit of a rock and a hard place, where you can actually say to your employer, listen, either you give me those 5 days back, right? We pretend this never happened. You put me back to 5 days, right? And I continue working as I've always worked. Or you pay me severance based on those 5 days a week of work. And we can call this a day, right? Again, claiming constructive dismissal, right? I'm not necessarily resigning, right? I'm considering you, the employer, to have breached the contract of employment here, and I'm owed severance as a result. And again, your severance is going to be based on your age, position, years of service. The longer you've been with the same company, the more senior your position, the older you are, the more severance you're going to be owed. And that severance, most importantly, Peter, is going to be based on that full work week, rather than the 3 days a week. If you silently just accept the status quo of this new 3-day-a-week work week, Peter, and say nothing in response, right? And I know it's been a couple of weeks already. You're probably at that point in time where you need to do something about this sooner rather than later. If you don't, your employer will be allowed to say, oh, well, he accepted the new status quo. He accepted the 3 days a week, right? He can't make an issue out of it, further down the line. Peter, probably the most important piece of advice I have here in your situation, before you say anything to your employer, before you talk about constructive dismissal, before you talk about severance, before you tell them that you don't agree with the change, it's extremely important in these circumstances to get legal advice. Speak to us first. Let's figure out a game plan as to how to deal with your employer, what to say and what not to say when you're dealing with this kind of situation. That conversation, however, needs to happen now. The longer you wait working this 3-day-a-week schedule, right, the tougher your claim is going to become if you want to take issue with it. You have the right to take issue with it. You have the right to either the 5 days a week or to severance, right? But the longer time goes on, the more difficult those claims become. So give us a call right away. Email us at help@employmentlawyer.ca right away. You need to deal with this situation as quickly as possible. And that applies to any kind of change to the terms of your employment, whether you're changing your work schedule, whether you're changing your position, whether you've been temporarily laid off. Don't wait. Act in the moment because it's extremely important. All right, we've got a couple of minutes left, guys, and a couple of questions. So I'll try and do these a little more quickly. Joseph on Facebook asks, I was diagnosed with PTSD and struggling at work. I was fired and not given any compensation and had my pay held back. I recently was told by an old coworker they might consider hiring me back because they are worried about legal action. I no longer want to return. How can I get what's owed to me? Well, Joseph, certainly if you are in Canada, number one, if you've been fired from your job, you are going to be owed severance as compensation. Severance is the starting point here. I don't care what kind of line of work, I don't care what you did, based on your age, position, and years of service, you are going to be owed some degree and some amount of severance, even if you were struggling at work. Not only that, Joseph, but when you raise this issue of having PTSD and struggling at work as a result, this to me raises concerns about potential discrimination in the workplace. So if your employer knew that you were having some mental health issues at work, if you had taken some time off for a medical leave of absence, or if you had expressed to them that you were struggling with these issues at work and your employer terminated you in response, well, guess what? That's discrimination. You cannot let an employee go because they're dealing with a medical issue, whether that's a physical health issue, if you're injured at work, or whether it's a mental health issue and you're dealing with PTSD or stress or anxiety. Your employer actually has an obligation to accommodate those kinds of issues. And terminating an employee on the basis of having those issues is discrimination under, in Ontario at least, the Human Rights Code. So, Joseph, I also have concerns there, and there may be additional compensation owing there if they terminated you as a result of your health issues. How can you get what's owed to you? That's the question you ask, Joseph. Well, you need to engage the company, and the way you want to do that is with an employment lawyer. Don't go to the Ministry of Labor in your province, right? You need to speak to an employment lawyer in your province as quickly as possible, right? And deal with both of these issues, both the severance piece of the compensation and also a potential discrimination claim. Joseph, if you're in the States, for example, or if you're in any other country for that matter, again, there are employment protections and laws in other countries. We obviously don't practice in those countries, but speak to an employment lawyer in your state or in your region. That is the starting point for sure. One last question to get it at the last minute here. Richard asks on YouTube, if I'm temporarily laid off and a lawyer is hired, how long should it take to contact the company for compensation? Is there a time limit? Well, the process should start right away. Richard, is the short answer to that question. Again, you want to get these matters moving forward as quickly as possible. There's no particular short-term time limit that really matters, right? Whether it's a week or a couple of weeks or a few days, ultimately that doesn't really affect the analysis at all. Keeping in mind that in Canada more generally, and specifically in Ontario, an employee ultimately has 2 years from the date of their termination to deal with any kind of severance claim. So there are no particular time limits here other than that 2 year mark that really matter. If you're disputing a temporary layoff, Richard, again, you do want to deal with that matter sooner rather than later. So don't wait a year or 2 years or anything like that, right? You want to deal with it right away, but there are no particular time limits that are of any concern. All right, guys, and with that, we will end today's live Q&A. Thank you all so much for tuning in. Thank you very much to those of you who have asked your questions. Not only have you had your questions answered, I guarantee there are dozens, if not hundreds of people that had similar questions that benefited from you asking your question as well. Once again, and for one last time, my name is Alex Lucifero, employment lawyer and partner with Samfiru Tumarkin, LLP. Thank you all for tuning in. Hope you have yourselves a great rest of the week. And tune in for our next segment, which I believe will be tomorrow for another live Q&A. If you didn't get your question answered here, or if you're just tuning in right now and haven't had a chance to ask your question, go ahead and tune in tomorrow for our next segment and go ahead and ask your question there. Until next time, everyone, take care and so long.